Good morning to everyone. The topic assigned to me is to talk about the legal provisions. I understand that the participants in this group consist of officers drawn from the Central Tax Department, Customs, as well as the GST officers from the state. While my endeavor is to talk to you on the legal provisions governing the adjudication in these three streams of taxes, namely the GST, the Customs, and Excise, we need to understand there's a common provisions which permit among the three legislations with minor variations. First and the fundamental when we talk about adjudication, we need to understand that we are talking about adjudication in a legalistic manner. Adjudication means to adjudge, to decide an issue which has to be resolved in a manner as established under law. So, in a way, when we talk about adjudication, it presupposes that a judicious approach in deciding an issue which could be a matter involving the legal provisions interpreted to a given business situation. So, you need to fundamentally know where do we derive this authority? How does the law mandate this entire process to be completed? And what are the procedural safeguards provided insofar as the taxpayer is concerned against whom the proceedings are initiated? And how an adjudication should be perceived to be fair and just from the point of view what Professor Samyukta has mentioned to you yesterday, adhering to the principles of natural justice. Let us deep dive into all these issues one by one. The first and the fundamental thing, how does the tax laws define adjudication? There is no definition for adjudication in the CGST Act or, for that matter, in SGST Act. The Act only defines who is an adjudicating authority. So by understanding this adjudicating authority, let us try to drive the meaning as to what law assigns for the word adjudication. Adjudicating authority, to start with, in terms of Section 291 of the CGST Act as well as the SGST Act, defines an authority appointed or authorized to pass a decision or an order. So mind these words very carefully. An authority appointed or authorized under law. So first and foremost, we look at the appointment of officers. You are well aware that Section 3, 4, 5, 6 of the CGST SGST Act talks about the powers and the appointment of officers and the exercise of powers in terms of even the Section 6 with regard to cross-empowerment. So it could be an officer appointed or authorized under the Act for what? For passing a decision or an order. A decision and order passing authority is called an adjudicating authority. But there are exclusions. If we talk about Customs Act, it excludes Commissioner Appeals and the board. If we talk about the Central Excise Act, it excludes the authority including the board and the appellate commissioner. In respect of CGST or SGST Act, the exclusions from the definition of adjudicating authority excludes authorities including the authority for advance ruling, appellate authority for advance ruling, the first appellate authority, the appellate tribunal, the authority constituted for the purpose of deciding the matters and anti-profiting under Section 171, etc., etc. So there are clear-cut exclusions as to who cannot perform the functions of an adjudication authority. So there are two parallels we need to draw here. An adjudicator decides a matter in the original jurisdiction. An appellate authority is expected to perform the function in the appellate stage. So therefore, there is a clear-cut demarcation. I just want my state counterpart officers to kindly take note of this aspect, because when we are talking about an appellate function, the tax laws very consciously makes an effort that an appellate function should be independent of the decision making at an executive level. Well, we all understand that we are revenue officers, we need to do the work as per the assignment under the Act. While we are adjudicating, we are performing the function which is more in the nature of an executive function, an administrative function, assigned by the law for us to do in a particular manner. An appellate authority enjoys a certain amount of independence or autonomy in deciding the matter in a proceedings where the submissions made by the aggrieved person vis-a-vis the person who has passed an order, if required, be heard and then decide the matter. Insofar as the second appellate authority is concerned, like tribunal, I think the proceedings are almost like a court proceedings where the submissions by the counterparties are heard and then decided in an impartial manner. Now, coming to adjudication, we all understand yesterday, I think the speakers would have spoken to you, the necessity of following the principles of natural justice. And they must have also spoken to you with regard to what is a quasi-judicial function. A quasi-judicial function would, literal meaning is that there is an issue or a dispute which is decided in which the person deciding the dispute has an interest. A lis or a dispute is between the self, the person who is deciding, and also to the person against whom or in the person concerned with on whom this order is getting passed. So quasi-judicial means it is a decision making by the executive under the administrative law in which a dispute could be a dispute relating to the person who is deciding the matter and the person who is otherwise adversely affected for whom this decision has to be made. I'll just take you through the provisions of the law before we get into that. The first and the fundamental thing what I mentioned was with regard to the adjudication jurisdiction. When we talk about the jurisdiction under central excise law, my colleagues who are attending from the Central Tax Department are aware that there is an enabling provision in terms of section 11A. You can say like what we have in CGST, SGST Act in terms of section 73 to 76, 73 and 74 more particularly. That section provides the powers for actually determining a tax which has not been levied, short levied or not levied or erroneous refund or excess input or credit availed or utilized, whatever the case may be. So there is an enabling provision which clearly stipulates what can be decided in adjudication proceedings. So an adjudication necessarily would mean a demand of tax or a demand of an erroneous refund, or it could be with regard to the correctness or incorrectness of the availment of input as credit, or for that matter, it could be also initiated for the purpose of imposing a penalty or fine. So if you look at GST law, the GST law in terms of section 73 provides for demanding a tax, not levied, short paid, not paid, erroneously refunded, ITC, etc. 74 talks about the cases of the same nomenclature what is narrated in 73, but with an element of suppression, willful misstatement, or for that matter, fraud. If you look at other provisions of the GST law, if it could be section 122, 123, 124, 129, 130, etc., etc., you have these provisions for imposing penalty. Even in those cases where you need to pass an order determining the quantum of penalty or imposition of fine, whatever the case may be, you need to adjudge those matters for which the law mandates that a notice is a prerequisite. I think some of you did discuss in the morning session with regard to the challenges with regard to the quality of the notices. So in all this adjudication, one presupposition is that while we understand who is the competent authority to pass an adjudication order, the second important thing comes to with regard to actually what is the enabling provisions. I'll just step back and talk the first point before I come to the legal provisions. Insofar as the adjudication powers are concerned, there are different approaches being followed. Even within the central tax, there is no uniformity. For example, in central excise, if you have to be an adjudicator, the powers for adjudicating is based on the monetary limits fixed. That is, depending on the quantum of tax involved, different hierarchy level officers are appointed as adjudicators. In central excise law, insofar as any adjudication relating to demand of tax is to be exercised, up to the power of tax involvement of 10 lakhs, it is the superintendent of the central tax, he is the proper officer. Because section 291 talks about in CGST Act also the proper officer. So Central Excise Act also has a provision for a proper officer. The monetary limits are assigned to the proper officer depending on the rank. From 10 lakhs to up to 50 lakhs, it's the assistant deputy commissioner. From 50 lakhs to 2 crore is with additional joint commissioner, and beyond 2 crores is with the commissioner. This is in so far as the central tax is concerned. It may not be there in state taxes because in state taxes, some of you follow the power by assignment by your commissioner commercial tax or any officer appointed by him. I'm just giving a flavor that the power to adjudicate could also be vary from one system to another system. As I told, within the central tax system, it's again, there is no uniformity when I said this. While the power to adjudicate in the central excise is 10 lakhs, 50 lakhs, 2 crore and without any limit for commissioner. Under the Customs Act, the power to adjudicate by a deputy commissioner, there is no power to adjudicate under Customs Act except for offences up to 1 lakh rupees. The demand of tax in customs is for the deputy assistant commissioner only up to 5 lakhs, to the joint additional commissioner 50 lakhs, and beyond that without any limit with regard to the commissioner. Again in customs, within the act, there are different powers assigned. I'm just telling you that why it is very important to know the law before you exercise the power. For example, if there is a demand of a drawback involving no suppression, the financial power is up to like rupees 5 lakhs for an assistant deputy commissioner. Sorry, where it is a suppression willful misstatement is 5 lakhs. If there is no suppression willful misstatement, the assistant commissioner can demand the recovery of an erroneously availed drawback without any monetary limits. Now, if it is involving an export-related fraud or export promotion scheme violation, again, the assistant commissioner's power is only 5 lakhs, whereas up to 50 lakhs with the joint additional commissioner, beyond that is with the commissioner. So the law will mandate exactly who is the competent or the proper officer for deciding an issue, either based on monetary limits or a subject matter of a dispute involved, both requiring either a demand of tax or imposition of fine or penalty. Be very watchful of that. And many a times, these prescriptions are not given in the law, in the source law, not even in the rules, but it could be in the form of an executive circular or instructions. So one should be very mindful and watchful of what exactly the powers conferred under the statute or in excess of the powers conferred under the central government or to the board or the competent commissioner. What are the instructions or circulars have been issued with regard to excess of the power? One has to be very, very careful about it. Coming to the GST law, so far the CGST is concerned, there are 2 circulars issued, one in 2018 and also in 2022. The 2018 circular clearly provides who is the proper officer and what are the powers he can exercise insofar as adjudication functions are concerned. Under that law, the circular issued by the CBIC in excess of the powers under section 168(1) clearly says a superintendent of the central tax can adjudicate an issue relating to 73 or 74 demand up to a monetary value of 10 lakhs of the tax involving CGST alone. If there is an IGST demand, that power gets into 20 lakhs. CGST plus SGST is 20 lakhs. If it is involving a CGST and some amount of an IGST, again the limit has been kept at 20 lakhs. If we look at the power of a deputy assistant commissioner, that same provisions, the same circular of 2018 says, if it is a CGST demand alone, the assistant deputy commissioner can decide an issue involving a tax or an erroneous ITC up to the limit of 2 crore. It's 1 crore for CGST and IGST 2 crore, IGST plus CGST is 2 crores. And beyond that limit, the additional joint commissioners can adjudge the matter without any monetary limits. But if you come to the position with regard to adjudging the penalty is concerned, whether it is under section 122 or with regard to any of those provisions, the powers again are very, very specifically provided for in the circular or instructions issued from time to time. Now, if you look at the 2022 March circular of the CGST, again the CBIC instructions circular, with regard to the cases investigated by the DGGI, the power to adjudicate subject to the monetary limits what has been discussed in the earlier 2018 circular, a further clarification has been issued. In that circular, very clearly it has been stated that in respect of cases investigated by DGGI involving GST registrations in multiple jurisdictions of the same PAN entity or an identical issue involving multiple taxpayers involving different GST and registration, consequent to an issue investigated for which notice is to be issued by the DGGI, the adjudicating powers have been given to an officer of the rank of Joint Additional Commissioner specified in that notification or circular issued with regard to an all India jurisdiction, where the highest amount of tax has been demanded in one of the GSTNs to that jurisdiction, the mapping will happen of the Joint Additional Commissioner designated by the notification to whom the notice has to be made answerable and he alone can adjudicate the matter. So this is again in terms of the executive instructions in the form of a circular. So one has to be very conscious about it before exercising the power of adjudication. If you exceed the jurisdictional limit to which you have been empowered to adjudicate, the entire proceedings can be called in question and they could be void ab initio. That means if something has been exercised in excess of the powers conferred under the law, any excess of such powers is said to have been exercised without validity or the approval of the law, and the entire proceedings can be quashed, saying that you have lacked jurisdiction to even adjudicate the matter. So be watchful of what has been given to you. If it could be a state jurisdiction, it could be an assignment power. It could be a central jurisdiction, it could be the monetary limits. Be very clear as to what the powers for adjudication is. One thing what I want to keep it very clearly focused as a legal requirement. The second point I was just dwelling upon the relevant provisions, the machinery provisions of the relevant act. As I told you in central excise, it's section 11A, and the formulation in the central excise is that the time limit for issue of show cause notice for a normal period of demand and the extended period of demand by virtue of the proviso to section 11A is different. The normal period of demand for issue of show cause notice in central excise is 1 year period from the relevant date. The relevant date is again defined as to what is the period from the relevant date will start. For the benefit of the state officers, let us look at section 73. Section 73 talks about a situation where an order required to be passed in terms of the time limit prescribed under the subsections 9 and 10. The time limit has been provided that 3 months before the time expiring for passing an adjudication order, that is the 3 years time limit from the relevant date. Here the relevant date would count from the date on which an annual return is required to be filed, or where it is an erroneous refund, the 3 years from the date of sanctioning of the refund. So one, in a machinery provision you will see the limit for issue of a notice. If a notice has been issued beyond the time limit, that it can be called into question is a time barring demand and the adjudicator is required to address that concern in the first part of the order itself. So this is very important. The second is, the important thing is with regard to, insofar as the time limit is concerned, there are different time limits for different acts, particularly for the central tax officers, they must be aware of this fact. In Customs Act also, the time limit for issuing the normal period of demand is 1 year and the extended period of demand is 5 years. In GST Acts, the normal period of demand is for 3 years and the extended period of demand is for 5 years. So keep this very clearly, because extended period of demand in terms of the tax laws as of prevalent today, it's basically for the purpose of invoking suppression, willful misstatement or the fraud element. Fortunately, the GST Act talks about only 3 situations where you can invoke the extended period of demand. 1, suppression. Second is willful misstatement. Third is basically with regard to fraud. It would be of very great interest and importance for the officers participating in this workshop to go through some of the case laws relating to excise and customs laws or service tax laws as to what constitutes a suppression, what constitutes a willful misstatement, what constitutes a fraud interpreted by the higher judicial forum. Because these words have been borrowed from the tax legislations of the central tax regime. Most of you in the VAT laws may not have had this type of a formulation insofar as the demand provisions are concerned. Obviously, every tax law would have dealt with some amount of suppression, willful misstatement, but the words used in 73, 74 are very clearly the formulations, what existed in our pre-GST law insofar as the excise and services is concerned. Both of us, Dr. Mr. Vinod Kumar sir and me, both of us were there as a part of the law committee. When we drafted it, we have deliberated in great length with the state officers as to how the demand provision should be worded in the model GST law. So what is relevant here is to keep it in mind that wherever you are invoking suppression, willful misstatement or fraud, I am talking about the GST law, obviously there is an attendant requirement also to look into the imposition of penalty. A penalty determination can happen right away within 73 and 74. The law is self-contained. 73 provides for a penalty imposition of 10% or 10,000 rupees, whichever is higher, in terms of the proportion to the tax going to be determined. Insofar as the provisions of section 74 is concerned, 74 also provides for, on own ascertainment or on being pointed out by the proper officer, a penalty could be paid by the taxpayer before issue of notice at 15%, 25% within 30 days from the date of issue of notice, and 50% from 30 days from the issue of order, failing which the penalty will automatically revert back to 100% of the tax proposed to be demanded, determining evasion in terms of suppression, willful misstatement or fraud. So keep this in mind that one of the points what I think the panelists in the morning stir about the timelines for adjudication. I think Ms. Deepa from State Tax Department mentioned about the challenges of an adjudicator in terms of adhering to the timelines because of the 3 months window given in the normal period demand and the 6 months time limit given for the extended period demand. Is this time limit sufficient for you to completely go through the records, voluminous records, the evidences used for the adjudicating purposes, and also passing an adjudication order in terms of well-reasoned, which is qualitative in outcomes?